Today we will be discussing about personal law, pluralism and uniform civil code. The law can be classified into several modes, as I said, public law, private law, civil law, criminal law, so on and so forth. One of such classification is the classification between secular laws and personal laws. Now, what is this personal laws and how did this evolve? Personal laws is an evolution of a long-standing history of England and as well as a history in India. In the West, in the initial stages of governance, the Pope, that's the church, used to look after many of the political matters of the state as well. It was known as Caesaro-Papism philosophy or doctrine. Now, at one point of time, it was noticed that the church was getting into all political decisions and the state was virtually being run by the church. And there were instances where the church was going into war with the princely states and capturing them in the name of religion and spirituality. Church at one point of time was self-pervading and trying to take over the entire governance of the state. In 1163, the Constitution of Clarendon said that the British Crown would also have power over the clerics. And in 1215, Magna Carta also stated that the British Crown would have power over the clerics. But till then, no such definite, clear demarcation was made. Eventually, when King Henry VII fell in love with Lady Catherine and wanted to marry her, the church refused to give permission to annul his first marriage. And it was then that he put his foot down and he said that come what may, he was going to marry Lady Catherine. And there was a division, a civil war-like situation where ultimately it was decided that the church will not interfere in the political decisions of the state and will retain personal matters like marriage, divorce, adoption, annulment, etc. with it. And the political decisions will be given to the state. This is the point of separation between the church and the state, and also the separation between the secular law and the personal laws, where matters of personal nature, such as marriage, divorce, adoption, inheritance, etc., were retained by the church, and the political matters were looked after by the state through the crown. So this is the point of evolution of personal law in the West. In India, our Shrutis did not have any clear demarcation about the personal laws and the secular laws. Shruti mainly devoted to certain basic spiritual principles which were useful in governance and which were useful in prayer and other religious activities. Spiritual religious activities, the Shrutis were very clear about. But the Smritis, especially Manusmriti, Narada Smriti and Brihaspati Smriti, the Smritis began to look at the personal activities or into the personal realm of social life. So in India, we see from the Smriti era, especially these three Smritis, the Manusmriti, Narada Smriti and Brihaspati Smritis, they devote a lot of verses to the development of personal laws in India. This was in the ancient India. In the medieval India, we have several Muslim invasions, but Muslims too respected the laws that were followed by Hindus, and they developed their own personal jurisprudence. So, at one point of time, the Hindu Pandits would look into the dispute that occurred among the Hindus, and the Musalman Maulavis would look into matters that occurred among the Musalmans. So, it was like a dual system where the Musalmans were governed by their own faith and Hindus were governed by their own faith. In case of Hindus, Manu Smriti, Brihaspati Smriti, and Narada Smriti were important sources, and in case of Musalmans, there was the Shariat, Quran, Hadith, Sunnah, Ijma, and Fiqh. These were the sources for Musalman governance. Musalmans also had several schools of thought for them. For example, the Sunni school, the Shia school, the Maliki school, and they had their own cultural differences and their own religious dictum to follow. For the Hindus also, there were two predominant schools, the Mitakshara and Dayabhaga. In the Mitakshara law, it is before the uncodified Hindu law. In the Mitakshara law, there was propinquity of blood. So the person who is nearer to you in blood would be the owner of the property, nearness of blood. And for Dayabhaga, it was religious efficacy, the one who helped you to achieve spiritual efficacy and who completed your last rites and oblations, that person would receive the property. In Mitakshara, the quantum of property increased with the death of the Koparsanar and decreased with the birth of the Koparsanar. So there was no absolute karta in Mitakshara system. It was a co-ownership of the property. Whereas in Dayabhaga system, there was absolute ownership of the karta and there were no sharing. Therefore, the karta could alienate the property as he pleases, whereas in Mitakshara, no one could alienate the property. They could manage the property, but they could not alienate the property. So, even in Hindu law, we find there were two schools of thought, the Mitakshara and the Dayabhaga school. And of course, among the Musalmans, there was the Sunni school, Shia school, and the Maliki school of thought. Then came the British period, and in the British period, initially they adhered to this system that Hindus will be governed by Hindu system and the Musalmans will be governed by the Musalman system. But they set up a third system in the presidency towns where any dispute among the English people would be tried in the presidency courts. As you are aware, eventually they set up the Supreme Court and the High Court, and the English judicial process and judicial system was gradually imported to India and set up in India. So some of the cases, both from the Islamic community and from the Hindu community, they started being referred to these courts in the presidency town. Now what happened was the English judges began to understand the tenets of Hindu law and Islamic law in their own manner, in their own cultural upbringing and their own socio-political understanding. So in many cases there have been distortions of understanding of these legal matters, but nonetheless the Privy Council was one forum where much of the matters of the Hindus and the Musalman people paved its way, and they were being litigated. But the English people also were weary of unifying the personal laws with the secular laws, and bring them in the mainstream for two reasons. One, they feared that the people would react very badly to such unification. The other was their own interest of divide and rule. They wanted to divide the Hindu community and the Muslim community, and we all know that ultimately they succeeded and the country was divided and fragmented eventually. So the British people, they played a game of neutrality, where apparently they kept the Muslim personal laws separate and the Hindu personal separate, and yet they also litigated or entertained litigation in their own Privy Council courts. Now, during this period, the Britishers also promulgated some laws on the Hindu side and also towards the Muslim people. All of you are aware that we have had the Sati Abolition Act under the leadership of Raja Ram Mohan Roy. We have had Widow Remarriage Act under the leadership of Pandit Ishwar Chandra Vidyasagar. There was Widows Estate Act. There were several such laws which were the Wills Act, which allowed the Hindus to alienate their property through wills. Similarly, among the Muslim also there was the Shariat Act. There was the Muslim Muslim Women Dissolution of Marriage Act, so on and so forth. There were divisions. This continued, and there were amendments and additions. This continued till the year 1947 to 1950. And in the meantime, several other difficulties especially among the Hindu communities, came into fore. For example, multiple marriage and Kulin Pratha, all these kind of things that were coming into the fore. So it was felt necessary after the this adoption of Constitution in 1950 that there should be a Hindu Code bill. Now, the Hindu Code bill did not come into as a Hindu Code, but within the Hindu Code bill there were 4 very definite enactments which came out in Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adoption and Maintenance Act 1956, and Hindu Minority and Guardianship Act 1956. All of these acts were promulgated by 1955-1956. And the Hindus continued with their personal laws. Muslims, of course, did not codify their law. They were free to continue practice their religion and practice their personal activities according to their religion laws. Now, among the Hindus, one of the significant things that happened was in the Hindu Marriage Act 1955, the definition was Hindu was given. Now, this definition included Sikh, Prarthana Samaj, Brahmo Samaj, Jains, and all of these subsects of Hindus, and unified them as Hindus. So when it is said under the law that Hindu Marriage Law Act applies to Hindus, it applies to Buddhists, Jains, Sikhs, the Prarthana Samajis, Brahma Samajist, the Veera Shaivas, then it applies to the Sikh, it applies even to the person who does not believe in God. So that is the definition of Hindu that came under the Hindu Marriage Act. Another significant development that happened under the Hindu Marriage Act was the requirement of monogamy. No person was allowed to marry if that person had a spouse living. Therefore, monogamy became a strict non negotiable rule. If you married a person while your spouse was living, then the marriage was void ab initio. Nothing can be done. It is non negotiable. On the other hand, the Muslims were allowed controlled polygamy. A Muslim man could have 4 wives at a time. The fifth wife would be irregular marriage, and it can be regularized if you divorced one of the earlier wives. So they were allowed to have a controlled polygamy of having 4 wives at a time. But the Hindus were given a very strict mandate that they could not marry while a spouse was living. Of course, a divorcee was not considered to be a wife. 1976, we see a lot of changes that is happening into the Hindu Marriage Act, where we also see that the women are given the right to repudiate their marriage. That is a very significant development. Desertion was given a wider connotation. The term cruelty was given a wider connotation. And eventually, we see Hindu marriage, which still remains a sacrament, but this act gives certain elements of contract into the Hindu marriage, which is not there in the Muslim marriage. In this sense, Muslims also have certain restrictions on marriage. The girl can marry only after attaining puberty. The marriage cannot take place if she has not attained puberty. And there is controlled polygamy. A person can have 4 wives at a time. But there is a system of dower in the Muslim marriage, which the woman gets in consideration of the marriage. This is not there in the Hindu marriage. In the Hindu marriage, there is no question of dower, but something very heinous takes place in most of the communities, that is dowry. In the Hindu marriage, the girl, when she gets married, this is customary, this is not recognized in law, it is illegal and punishable in law, and yet this practice continues that when a woman is getting married, she pays dowry to the groom. Conversely, among the Muslims, when a woman is getting married, she gets dower from the groom. It can be deferred, it can be paid at a later date, and it can be considered at the time of after the death of the person. It has to be, a dower has to be paid off first. But the beauty is that in the Muslim marriage, the wife gets dower, and in the Hindu marriage, the bride has to give dowry. Similarly, there was the Parsi Divorce and Marriage Act and Christian Marriage Act. Christians also had a separate act for divorce, the Divorce Act. Now, the difficulty in this act was the Christian groom, if he wanted to divorce the woman, then he had only to prove adultery. But if the woman wanted to divorce her husband, then she had to prove not only the adultery, but also something more like cruelty, desertion, etc. And in proving the adultery, she would have to give the name, address of the respondents, which became very difficult for the woman to do, and it was discriminatory as well. For the Muslims, we know the system of triple talaq was there. The woman did not have a right to give a talaq. From that point of view, the Parsi Marriage and Divorce Act appeared to be balanced in the sense that there were certain ceremonies of marriage for the Parsi marriage, and both had the right to divorce. Now, this was the scenario till 2005. In the Hindu Succession Act, the daughter was given, daughter, mother were made class 1 heirs, and they could share the property of the deceased. But the woman's property, if she had no heirs of her father's side, would revert back to her husband's heir, and her property would be given to the husband's heir, provided she did not have her any children. So this was the situation under the Hindu Succession Act. In 2005, the women were made copasaners, and they became co-owners of copasanary property. This was a significant change after a lot of fight with the government to obtain equality. Now, the government thinks that we can obtain equality through uniform civil code. Rather, uniform civil code will bring equality. The constitution also mandates that the country will have a uniform civil code. But every time the uniform civil code has been mooted, there has been very serious and severe repercussion. One of the questions that comes is, will uniform civil code bring equality between men and women as is desired? Because there are a lot of discriminations among them in the Muslim law as well as in the Hindu law and also in the Christian law. Muslim law, for example, makes it compulsory for the Quranic heir to receive property, and the woman, daughter, mother, wife, widow, daughter are Quranic heirs, but they get half the property of their son, so there is no equality. In Shah Banu's case, Shah Banu had filed a suit for maintenance under Section 125 CRPC, which is a secular section, because her dower was not sufficient and she was not being given any other separate maintenance. And we all know the furor that took place, and the result being the Muslim Women Protection on Divorce Act, which says that her all payment should be given within the iddat period. And in Daniel Latifi, the court said that the period of giving the maintenance should be within the iddat period, but it should take into account the future requirement of the wife as well. So it was a one-time lump sum payment, but it was quick. The Supreme Court made sure that the woman was not left destitute. But among the Hindus, this requirement was not there. But eventually, it was added that all payment should be cleared within 6 months. So there also uniformity is brought in the piecemeal manner and not through uniform civil code. Similarly, the process of marriage. Under the Special Marriage Act, we have interreligious marriage made possible, because a Musalman man can marry a Kitabiya, but a Musalman woman cannot marry a Kitabiya. A Musalman man can have 4 wives at a time. The Musalman woman can have only one husband at a time. The Musalman man can divorce his wife through 3 talaq. Musalman wife has no right to talaq unless the husband permits her to give divorce to him. So there are a lot of discrimination there. Among the Christians also, you see, until 2005, till the act was amended, the wife alone could had to prove adultery and something more. But the husband could only divorce on the ground of adultery only. So there was a discrimination there, which was done away with in 2005 again. So progressive equality was being brought forward. The latest being the case on Shaira Banu's triple talaq case, and we have the Muslim Women Protection on Marriage Act, where triple talaq has been made illegal and punishable. So these discriminations are there in the personal law, and it is believed that promulgation of uniform civil code will bring about a change into the situation, and it will bring about parity and equality. But at the ground level, the difficulty remains. A, right now we do not know whether any draft uniform civil code is taking place or not, if at all. B, the communities, religious communities, are not willing to go in for a marriage which does not have a religious connotation. A simply registered marriage is not acceptable to many of the religions in India. See, the grounds of marriage, they are not uniform. D, the women do not have equal right with the men right now. So the question is whether uniform civil code will bring about a parity in all these matters. It is expected rather that uniform civil code will be gender equal. It will bring about parity. But the reality still remains that the communities in India, the religious denominations, the plurality of India is not willing to accept a uniform civil code as of now, though it is hoped that in near future uniform civil code will be brought about, keeping in mind the fear of the women, especially regarding their rights and their protection. One of the important aspects that the Uniform Civil Code will have to take into account is the issue of domestic violence, education, etc. And one very important aspect is that of adoption, which is now at the national portal. It is a-religious, it is online, and it requires a lot of procedural activities. Whereas among the Hindus, it was a simple form of adoption of the children through dattak homa and a deed of adoption and things like that. So there are difficulties in bringing about the Uniform Civil Code as of now, but it is desirable and it is hoped that Uniform Civil Code will come into the fore and try to bring about parity in all religious laws and result in equality among men and women and uniformity in personal laws. Thank you so much.